Gary DeWaal here, and this is Bridging the Week for November 9th to 13th, and today is November 16th, 2015. Bonjour. In a week punctuated by a horrific Friday night tragedy in Paris, far less important developments regarding cybersecurity dominated regulatory and legal developments for financial services firms. A New York regulator appears poised to introduce cybersecurity regulations for many types of financial institutions, while criminal complaints were filed in New York and Atlanta against major hackers of financial services firms. Separately, a federal judge in New York severely criticized the Securities and Exchange Commission over its handling of a case that caused a foreign bank to fail. It's with a heavy heart I review this week's top stories, but let's get started. A federal judge in New York severely chastised the Securities and Exchange Commission over its handling of a lawsuit against Caledonian Bank Ltd., Caledonian Securities Ltd., and others that resulted in the financial institution's bankruptcy and liquidation. According to the judge, the Honorable William H. Pauley III, the SEC initially filed a complaint against Caledonian, a bank and broker-dealer in the Cayman Islands, on February 6, 2015, in which it alleged that the defendant sold large quantities of worthless stock as a principal without filing required registration statements with the agency. After the SEC advised the court that it had identified, quote, recent transfers of funds, end of quote, by Caledonian and another defendant, Vermont Capital SA, from certain of their U.S. accounts, the court granted the agency's application to freeze defendants' assets. However, as soon as the following day, noted the judge, counsel for Caledonian and Vermont advised the SEC that each defendant had acted solely as a broker in the relevant transactions and not as a principal. This information was not shared at the time with the court. Unfortunately, a run on Caledonian began when news of the SEC's allegations spread, quote, and panic ensued among depositors and investors, end of quote, said the judge. Within days, the Cayman Island Monetary Authority placed both Caledonian entities into controllership, and the bank began a process of voluntary liquidation. It was not until May 2015, said the court, that the SEC advised it that Caledonia and Vermont had a far more limited role in the unlawful sales than previously described. Moreover, said the court, it turned out that other employees of the SEC, in other divisions and offices, had been aware that Vermont had acted as a broker and not as a principal in the subject transactions at least 5 months prior to the filing of the SEC's initial complaint in this action. Judge Pauley severely criticized the SEC's lack of internal coordination and heavy-handed approach in the majority of his 32-page ruling on a motion by Vermont to summarily decide against the SEC in connection with its amended complaint. The court, by the way, ruled such application was premature at this point. The New York State Department of Financial Services issued a memorandum addressed to 18 federal and state regulatory organizations, previewing that it will soon issue new regulations to increase quote-unquote cybersecurity defenses by financial services firms and encouraging the organizations to collaborate on instituting, quote, strong cybersecurity standards for financial institutions, end of quote. The New York State Department of Financial Services indicated that its regulations will require financial institutions to adopt cybersecurity policy and procedures that must address certain enumerated topics. These would include, among other things, third-party service providers. Financial services firms would also be required to appoint a chief information security officer, have adequate personnel to manage a firm's cybersecurity risks, provide mandatory training to cybersecurity personnel, conduct annual penetration tests and quarterly vulnerability assessments, and to immediately notify the New York State Department of Financial Services of any cybersecurity incidents. Federal prosecutors filed criminal charges against Joshua Aaron, Ziv Orenstein, and Jerry Shalone in New York, and Mr. Shalone and an unnamed individual in Atlanta for, quote, orchestrating massive computer hacking crimes against unnamed U.S. financial institutions, financial services corporations, and financial publishers, including the largest theft of customer data from a U.S. financial institution in history, end of quote, involving 80 million customers from 2012 to mid-2015. According to an indictment filed against these individuals in a federal court in New York, defendants also endeavored to artificially manipulate the price of certain stocks that they sought to market customers whose personal information they stole. Additionally, Mr. Shalom is alleged to have coordinated computer network attacks against companies outside the financial sector to benefit other of his unlawful businesses, including internet casinos and a U.S.-based exchange that traded Bitcoin. In connection with the criminal action filed in Atlanta, the defendants were charged similarly for hacking into the computers of E-Trade Financial Services and Scottrade Financial Services, as well as other financial institutions and companies, too. According to the indictment filed in Atlanta, more than 10 million customers of E-Trade and Scottrade were quote-unquote compromised by these attacks. BGC Financial agreed to pay a fine of $42,500 US to resolve charges brought by a business conduct committee of IFIS that on multiple instances in connection with black trades it had failed to record and maintain oral communications leading to the transaction's execution, to report the correct execution time, and to adequately supervise brokers' block trade activities. IFIS, of course, is ICE Futures US. According to the relevant IFIS rule, all members and non-member Futures Commission merchants and introducing brokers must, quote, record and maintain, end of quote, all oral and written communications leading to the execution of exchange futures or options contract and related commodity, cash commodity, quote, whether communication by telephone, voicemail, mobile device, or other digital or electronic media, end of quote. Finally, JP Morgan Securities agreed to pay a fine of $350,000 US to the Financial Industry Regulatory Authority as a result of multiple violations of Securities and Exchange Commission regulations show, principally between October 19, 2011 to January 27, 2012, caused by alleged systems issues. According to FINRA, the firm's problems derive from a coding error in a change to the firm's automatic market tool it used to assist traders make two-sided markets in securities. The coding error, said FINRA, caused the firm to execute over 21,200 short sales during the relevant time period without a quote-unquote locate. Under Reg Show, a broker-dealer engaging in a short sale in its own proprietary account must first borrow the security, enter into a bona fide arrangement to borrow the security, or have reasonable grounds to believe the security can be borrowed before the delivery date, thus satisfying its so-called locate requirement. After the problem was detected, JP Morgan immediately suspended use of the automated tool, and a few months afterwards self-reported the problem to FINRA, acknowledged the regulator. FINRA said that part of JP Morgan's fine was attributable to quote-unquote supervisory violations. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more article on the article version of Bridging the Week on the website. Check it out. This is Gary DeWaal, bon semaine, and au revoir.